Morning, everyone. This is the Judiciary Committee hearing for February 9, I guess it is. I'm totally losing track. Yes, February 9, 9:15 agenda. My name is Carl Rhodes. I'm the chair of the committee. This Zoom meeting and YouTube live stream event will include the following agenda, the 9:15 agenda. Also on the committee are Vice Chair Jared Keokalole, Senator Casio, Senator Gabbard, Senator Lee, and Senator Kim, and Senator Favela. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this hearing due to major technical difficulties, the committee will reconvene to discuss any outstanding business on Friday, February 12 at 9:10 a.m. and a public notice will be posted on the legislature's website. For the people testifying remotely, all testifier audio will be muted and video disabled until it's your turn to testify. There's a 2-minute time limit per testifier, and there'll be a little clock so you can see where you are in your 2 minutes. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person. We appreciate your understanding and remind you that the committee has already received your written testimony, but if we can work out the technical difficulties, we'll have you come back and finish up. I'll be reading some of the lists of people who submitted written testimony. We apologize that the closed captioning doesn't accurately transcribe the names. If you're interested in reviewing the written testimony, please go to the legislature's website, www.capitol.hawaii.gov. You'll find a link to testimony on the status page for the measure. And as usual, members will ask questions after we've heard all the live testimony. Okay, so we start off today with SB 540. This is relating to emergency rules. The current situation is that under Chapter 127A, only a misdemeanor can be charged for violations of emergency orders. So this bill would make it so that the mayors and the governor can prescribe different rules, lesser penalties if they decide to. We did post a proposed SD1 on this bill, and that's what the testimony will be about. Okay, first up on SB 540 is James Tabe, Office of Public Defender.
Good morning.
Morning.
Thank you, Chair, Vice Chair, members of the committee. I'm James Tabe with the Public Defender's Office. We support this measure, or any measure which actually creates a civil infraction for violating the governor or mayor's emergency rules. Currently charging citizens with misdemeanor offenses for many of the minor violations is just simply unfair and unjust. As indicated in our testimony, many law-abiding citizens, including the Surgeon General, were charged with a crime for the first time last year. I can't imagine how many phone calls or personal phone calls I received from people that are basically complaining that their parents and grandparents for the first time was charged with a crime or got the citation. And after I told them that the maximum is 1 year, I mean, they were just horrified, and I had to calm them down. So a civil infraction is probably the most efficient and effective sanction for these types of violations. Instead of having to hire an attorney, spend the money, go make multiple court appearances. And in one occasion, we had just last week, we had a 3-day jury trial on emergency orders violation. We actually spent 3 days in this case. It turned out to be an acquittal. So it's just completely a waste of time trying these as a misdemeanor. Will this civil infraction be deterrent? I'd say yes, even multiple. I kind of compare it to seatbelt violations. I know people with maybe 1 or 2 violations. I don't know anybody with multiple, number of violations for that. People will learn their lesson. So, and I know my time is just about up. I'll be available for any questions later. Thank you.
Thank you very much. Next is Lance Goto, Deputy Attorney General, and support. Mark Santoki, Deputy Chief Court Administrator. With comments, Tricia Nakamatsu, Deputy Prosecuting Attorney.
Hi, Senator Rhodes. Tricia Nakamatsu is not in the Zoom room at this time.
Okay, they're in support as well. Those are the only two, I believe, that signed up to testify in person. So the remaining roughly 40 testifiers are solidly in support. There's a couple that are in opposition, a couple with comments, but that's it. I'm not going to bother to read the names. If you want to read the testimony of both members and members of the public, you can go to the website and take a look, but overwhelmingly in support. Okay, members, any questions?
I have a quick question, Chair.
Sure, Senator Kim.
Just on the period of time. So it's basically the governor has to do the proclamation, and the proclamation lasts for 60 days unless he extends it. And so that's the same thing for this. It would fall under the same under rules.
Yeah. Yes. I think I understand your question. Yeah, he can. So under the proposed SD1, he can specify different penalties that are misdemeanor or lower. And if he doesn't specify what the penalty is, then it automatically defaults to misdemeanor. But it gives him the option to specify what the, if he thinks mask wearing should be $100 fine,
Right.
and he puts that in there, and that's what it is.
Right, but the period of time is the same as his emergency orders, right?
Yes,
60
we don't-
days unless it extends it.
Yeah, we don't change that. I think it's 60 days.
Right, 60 days.
Yeah, but yes, they can renew it. Obviously, it's been renewed multiple times.
Right, okay, appreciate that. Thank you for that clarification.
Thank you. I do have a question for Mr. Tabe. So my understanding is the prosecutors have dropped a whole bunch of these cases. I mean, I think there were 60,000 citations written on Oahu alone. Do you know where that, does your office track how many have been,
No, we don't, because if they get dismissed, because I understand that they're trying to do their best, and they do dismiss cases before they even get to their first appearance. So I commend them for that. But usually what happens is, I think at the first appearance, when there's no attorney available, I believe the prosecutors are trying to reduce, they'll offer the defendant if an infraction, they'll cut it, they'll reduce it to simple trespass or they'll find an infraction, a civil infraction, and many do plead, they'll take that deal, plead guilty, and be done with it. But once we get through that process, once we're involved, when they refer the matter to the public defender's office, we get a number. I mean, it varies, just like most cases. We try to present them with a case, and sometimes they will dismiss the cases. Other times they, we'll try to reach a middle ground and try to get the infraction with them. But it is time consuming.
Yeah.
And
Well,
in one case, we went to trial on, and we actually demanded jury, and there was a trial at Mount
I understand. Well, so you don't have any numbers on it. So that's what I was curious about. Okay. All right. Members, any other questions?
Just another clarification.
Sure, Kim, go ahead.
So the prosecutor can already lessen it, right? Without the governor's proclamation.
That would involve our office, and that would probably involve multiple court appearances. It's the negotiation process, so it's really it's quite inefficient way to do this. But yes, right. I mean, ultimately, because the person that went to trial was offered a $75 fine, before he he rejected it and demanded his jury trial. So yes, they can. But if people are adamant about their that they were not guilty, many of them will say, they'll roll the dice, so to speak.
Thank you.
Okay, thank you. Members, any other questions? If not, I think we can go ahead and move on to the next bill, which is SB 1359. This establishes an offense for placing written materials on state or county property without prior approval. First up on 1359 is Mr. Tabe again from the Office of Public Defender.
Good morning again.
Yeah, 1359.
Yeah, 1359. We oppose this bill because the measure is overly broad and I think will criminalize behavior long considered acceptable. So basically, we think individuals here, the way it's written, can be prosecuted for posting a lost pet sign, birthday party directions, garage sale notices. You know, in my community, I see that before the pandemic, I used to see it, you know, every weekend, you know, on Saturdays. So, and the people that post pet signs, there's multiple violations, you know, they put up all over the neighborhood. And those are the people we would be criminalizing at this point. And I think, again, as with the previous bill, I would imagine that a person that gets a civil infraction or citation and the first time you pay the $100, I don't think they're going to repeat their offense again. So I think the penalty is just unnecessary. Otherwise, I'll we'll stand on our testimony.
Okay, thank you. Next, we have Department of Transportation. I don't know if they were planning to appear here today. Doesn't look like it, but they're in support. And that's all the testimony we have. Members, any questions?
Yes, I do.
Senator Favela.
Yeah, hi. The reason why this, I don't think this bill, the way it's written, is necessary because even the Department of Transportation, state and city, don't know the jurisdiction. And I go explain, in my community, the fence belonged to the golf course. But guess who came down and took down the banners from the community when they were doing advertising community events? The Department of Transportation. So we had to go down there, pick up 15 banners to find out that they had no jurisdiction on that fence. So unless the Department of Transportation is going to put out there on a website or in a community advertising that they're not going to have to let the people know what is state and city or what they're saying in this bill, then you're going to be criminalizing a lot of people. A lot of people are going to be getting criminalized under this bill. I mean, we understand in all of our communities, we don't like signs all over the place and staying up for months and years at a time. But even they don't know their jurisdiction. So now they're going to take down your sign, send you on fine. You got to go to court. You got to fight them and then find out, oh, that wasn't their property and they was wrongfully giving you a ticket. Now you wasted the person's time to go to court. Probably have to give a lawyer because he doesn't want to be criminalized. It's just a waste of time.
Okay.
Waste of time. Thank you.
Thank you. Members, any other questions or comments?
I have a
Senator Kim.
question.
Senator
Thank
Kim,
you.
followed by Senator Acosta.
So Mr. Tabe, so this includes political signs as well, correct?
Yeah, I would imagine the way the bill's written, it includes political signs as well. So,
Which is one of the biggest infractions that we're going on.
I'm sure you don't do that, but yes, it is.
So currently, if you do put it, is there a civil fine? The current law?
I don't believe there is any. Well, I live in a community association, so there is a fine for that. We get that, but otherwise, I don't believe there is anything of that nature.
Okay.
It might be in the city county code. I don't know if they have one, but as HRS, I don't know. I'm not aware of one.
So would you be more in favor, instead of making it a misdemeanor, that it becomes a fine, a civil fine?
If it's a problem and if this legislator, I probably would not. I'd be more amenable to a civil infraction. Yes.
Yeah, well,
Because
'cause
again, I
political
said-
signs, yeah, political signs on state property is always a big problem going on. And I know they confiscate the banners, but, and that's a lot of money, but doesn't deter them from.
Yeah, but you know, the one problem I do note on crimes or infractions like these it's almost the person that has to be caught putting the sign up. It's
Right.
going to be very difficult to prove just because there's a vote for Don Ricardo Kim sign on a utility pole or state property. We don't know who put that up.
Yeah, but shouldn't the candidate be responsible though? I mean, if you're having people put it up for you or whatever.
If it's a civil infraction, it's more strict liability. So yes, it would be easier to prove, I would imagine.
Okay. Thank you. Thank you, Mr. Chair.
Thank you, Senator Casio.
So yeah, the way this bill is written, it's very vague and it doesn't, there's a lot of gray area, like Mr. Tabe had mentioned, even noting who put up a sign. Obviously, if it's a political sign, that's a little bit clearer, but some other signs may not be so clear. And also the level of mens rea it's really vague in terms of knowing, does the person know who owns the property? And so that becomes very clear. I'm in agreement with that with Senator Favela. Yeah, so that's all for my comments at this time. Thank you.
Okay. Any other questions or comments, members? Okay.
I'll get one more, sorry. One
Oh,
more, Chair,
Senator
sorry.
Favela, go ahead. Senator Favela.
So exactly what Senator Kim said. I think this bill was established because of a lot of the political advertisement would be all over the place and no consequences. So there's any way that we can make an amendment to the bill to just specify, because like how the public defender said, guys who putting up dog signs or for sale signs, garage sale signs, they're not leaving it up for months at a time, and some of them don't even know a jurisdiction. But as a candidate, you should know where state, city, and where you should and should not put one sign for advertising for your campaign, and putting them in a video strip of a freeway or a city highway, you're in violation. I just figured if we could do something like that, I'd be more keen to want to.
Sure, we can talk about it in decision making, right, Chair?
Yeah, there'll be more discussion. Thank you, Senator Favela. Any other questions or comments? Okay, let's go ahead and move on to the next bill, which is SB 148. This requires certain landlords, lessors, or plaintiffs in a summary possession action to provide proof of payments of taxes due to the state as a condition of the issuance of a writ of possession. This is SB 148. First on 148 is Isaac Choi, Director, Department of Taxation.
Hi, Senator Rhodes. Isaac Choi is not in the Zoom room at this time.
Okay, there have comments. Ken Haraki, Director of Governmental Affairs, Hawaii Association of Realtors, in opposition, and John Honda in support. That's all the testimony we have. We don't have anybody to ask any questions of, so I guess we will move on. Next up is SB 163 relating to childhood sexual abuse. This amends statutory limitations on the time period in which a survivor of childhood sexual abuse may file a civil suit, allows for punitive damages, permits the court to order restorative justice matters at its discretion if requested by the victim. First up on 163 is Karen Inagaki, Deputy Attorney General. Morning.
Good morning, Chair, members of the committee. Karen Inagaki, Deputy Attorney General. We've submitted written testimony, so I'll make this very brief. Certainly, we understand the reality that child sexual abuse victims do need additional time. We just wanted to point out that the longer the time is, it does create some evidentiary problems. We are currently facing that in our office right now, where all the witnesses are gone, the documents are gone, the perpetrator has passed away. So there are those concerns. And also, there's one other thing we pointed out in our testimony. Because we are now electronically filing, that we are suggesting a change to clarify in subsection E to include that the certificate of merit shall be electronically filed under seal. So those are the only comments we have. Thank you for the opportunity to testify, and I'll be available for any questions. Thank you.
Thank you. Next, we have Michael Galoyo Jr. for the LGBT caucus of the Democratic Party. Morning.
Good morning, everyone. Michael Galoyo on behalf of the LGBT caucus. This is a priority bill for the LGBT caucus. It has been for several years since the sunset, the extension had sunset. We believe we are asking for an amendment to the bill to remove the 50-year cap. We have great faith in our legal system. We saw when we had what we've been calling a pilot project when they took away the statute of limitations, and we able to see people to come forward and get justice for being victims of childhood sex abuse. So we think that the cap should be lifted, and we have great faith in our legal system that they're going to be able to come up and deal with those problems of that the previous testifier spoke to, that there was no, we've seen it. We think our legal system can handle it. We ask that you remove the 50-year cap because there shouldn't be a stopwatch on justice, especially for victims of childhood sex abuse. I'm available for any questions, and we thank you for hearing this bill. Aloha.
Thank you. Next, we have Nahalani Webster, Hawaii Association for Justice.
Hi, Senator Nahealani Webster is not in the Zoom room at this time.
Okay, they had comments. Next, we have Cindy Shimomi Saito for Executive Director, Sex Abuse Treatment Center. Morning.
Good morning, Chair, Vice Chair, members of the committee. My name is Cindy Shimomi Saito, and I'm the Executive Director of the Sex Abuse Treatment Center. We stand on our submitted testimony. We're in strong support of this measure with amendments. Thank you.
Thank you. Next, we have Nancy Kriegman, Domestic Violence Action Center and support. Youngji Overly, AAUW of Hawaii in support. Chris Cofield, Executive Director, Remua Alliance in support. Ryan Kushimoto, Parents and Children Together in support. Cheryl Hauk. Hi. Hello, good morning.
Good morning, Senator Rhodes. Thank you so much before I begin for having these videos. Many of you already know I live in Michigan, although I grew up in Hawaii, and I usually travel all the way to come to your committee meetings. I am here as a victim, as a 58-year-old victim, to fight for this bill because there are so many people that I even asked to come and testify today who are already still scared to come out and to have their voice heard. And when you put a limitation, I'm not going to go into the whole story, but what I'm going to say is that predators of children that are sexually abused, they know how to manipulate emotionally, physically, in every way a child to scare them so that when they're 50 years old, it takes a lot just to even bring these to court. And so I just beg you to give people the opportunity. And I want to agree with Michael that I believe in the court system. I went through it. I don't need this. I went through your court system, and you do a really great job at making sure the certificate of merit is there and that all of the laws are followed. We've tried to get a bill like this passed for a pretty long time. I think I'm on year 5. And I think it's time to do it. Please support this bill. And if you have any questions, I'm always here on Zoom. And I guess that's all I have to say today, Senator Rhodes.
Thank you very much. Next, we have Victor Ramos with comments. Okay, Cheryl B. in support, Michael Galoyo Sr. in support, Christine Johnson in support, Melissa Roshoff in support, Esquire, Dwayne Sosa in support, Justin Mark Hideake Salisbury in support, Kamala Warner in support, Tina in support, Karjabola Karulis for the Hawaii State Commission on the Status of Women in support, Lori Field, Planned Parenthood Votes Northwest in Hawaii in support, Jessica Munoz for Ho'ola Napua in support, Ann Freed in support, Victoria Murphy in support. That is all the written testimony we have. Members, questions? Okay, let me see if I have any. And I did have one for the Hawaii Association for Justice, but they're not here, so I will not ask that one. Okay, anybody else? If not, we'll go ahead and move on to the next bill, which is SB 1286. This makes an appropriation to the Office of the Prosecuting Attorney for Hawaii. First up on 1286 is Department of Prosecuting Attorney Honolulu in support Erdogan Gulari, in support Douglas Shannon, in opposition Alan Bartolome, County of Hawaii Office of Prosecuting Attorney, in support Anita Cook, in opposition Heidi Krull, in opposition Claudia, in support. And that looks like it. Well, there's no one to ask questions of, so we'll go ahead and move on to SB 288. This establishes the offense of unauthorized attachment of an object to a fence, gate, wall, or other structure, which is committed when a person knowingly attaches an object to a fence, gate, wall, or other structure or barrier without the owner's permission. First up on SB 288 is James Tabe, Office of Public Defender. Morning again.
Good morning again. The Office of Public Defender stands on its written testimony in opposition. We're available for questions.
We have on SB 288. Will anyone have any questions on SB 288? Seeing none, let's go ahead and move on to SB 307. SB 307 would include any firearm or rifle with the capacity to fire ammunition of 50 caliber or higher in the list of prohibited weapons. First on this one is John Bickel, President, Americans for Democratic Action, in support. Chad Diaz, Hawaii Rifle Association, in opposition. Donna P. Van Osdol for Hawaii Federation of Republican Women, in opposition. Chase Cabot, testifying for Pacific Arms Company, LLC. Opposition. Dale Ayama, testifying for Young Guns, in opposition. Okay, here's the ones who have signed up. John Abbott, Director, Hawaii Firearms Coalition. Go ahead. Good morning.
Good morning, Chair. Thank you for having the hearing. We basically wanted to oppose this bill primarily because the definitions used in the bill are vague and have unintended consequences. So for instance, the bill states that it bans anything 50 caliber or larger. Definition of caliber is simply the internal diameter or bore of a gun barrel. And as my testimony actually states, if this bill is passed, it would ban all shotguns because the diameter of a shotgun, typical 12 gauge shotgun, is 0.725 inches or 72 caliber. So basically this bill would ban all commonly used shotguns, and even worse, it would actually ban muskets, the actual muskets used in Revolutionary War, particularly the Brown Bess, which is over 50 caliber. So we oppose this bill, and I'll be available for questions if anyone wants.
Okay, thank you. Next is Todd Yukutake. Is he here?
Hi, Senator. He is here. I'm trying to get him to start his video.
Okay. We will wait.
Aloha. Thank you for having me here. I'm Todd Yukutake. I oppose this bill because it would ban a lot of common firearms, such as not just. I'm assuming this bill's purpose is to ban 50 BMG rounds, but also ban shotguns, because this is a shotgun slug from a 12 gauge, which is a very common thing for people to have for self-defense, hunting, etc. But this is actually 3/4 of an inch wide. So this would be banned, very common. There's probably millions of shotguns out there. Another thing that this bill would ban is muskets. You know, the original firearms used in the War of Independence. This is a musket ball. This is a ½ inch wide. There's even others that are larger than this. So muskets, the original farm for the Revolutionary War, would be banned. This bill is also unconstitutional. You know, you don't want to start picking and choosing which firearms are banned, because what's next? Are you going to ban assault rifles or you know, other types of firearms next? And this is a constitutional right. Just because you don't like something, you hate something. Oops, sorry. Yeah, just because you don't like something doesn't mean you have to ban it. But that's why I'm opposed to this bill. Thank you very much.
Thank you. Next we have Michael Rice.
Oh, yeah, sorry.
Hello, Michael Rice here. To stand out, the others have said this would ban not only 12-gauge shotguns, like since they can actually chamber the 50 BMG round, although that's a very bad idea to do. It would also ban a slew of hunting calibers, such as 500 Smith & Wesson, which is used for dangerous game hunting, and a slew of other rounds like 50 GI, which is a competition round. Basically, this bill is just so poorly worded that I think whoever wrote it thinks that they're banning some sort of anti-tank round, which is simply not true. Like 50 caliber does not automatically mean more powerful. Many 50 caliber rounds are very powerful, yes, but caliber has nothing to do with power. I believe that's all I wanted to make my point across. I'll be muting the rest of my time.
Okay, thank you very much. Next we have Marcus Tanaka. Morning.
Hello. You know, again, I don't want to copy what everyone is saying, but pretty much I agree with all the guys prior to me. But I want to add, you know, this would ban not only the shotguns and muskets, and then on Friday there's a bill to ban semi-automatic rifles. So you look at all the firearms that are being banned just this week alone that are trying to be banned. What's next? Are handguns next? You know, I mean, we hit shotguns, we hit muskets, we hit semi-automatic rifles, we hit semi-automatic shotguns that accept the detachable magazine, which is also on Friday. So when is this going to end? And the Second Amendment right is the right to bear arms. And that's what this bill would be violating. And not only with the shotguns, you know, you have people who do skeet or trap shooting. That's, you know, those orange discs, clay discs that go flying across, and that's what a shotgun is used for, which this law would prevent people from doing that type of sport shooting. And yeah, that's all I had. Thank you.
Thank you. Next we have Eric Ako, DVM. Is Eric, Mr. Ako here? Oh, there you are. Go ahead. Except we can't hear you. You need to unmute. Okay.
Hello.
Morning.
Can you hear me now?
Yes, go ahead.
Yes, good morning, Honorable Chair. Just going to stand on my testimony. Thank you very much.
Okay, thank you. Next is Micah Tanawai.
Okay.
Hi, Senator. Hi, Senator.
Yes.
Micah Tanawai is not in the room at this time.
Not on there. Okay, he's in opposition. Next is Ryan. I'm sorry if I mispronounce your name. Tina Yero. You need to unmute.
Yes, sir. It's pronounced
Morning.
Tina
Go ahead.
Chair, Vice Chair of the Senate Judiciary Committee, thank you for your time. All right, so I won't belabor the points that have already been addressed. The points that I want to address include that this bill, well, the measure in its current form does not serve any valid public benefits. When you look at the data as cited on line 5, when it refers to the CDC indicating the lowest number of gun deaths per capita among the states of 2019, the CDC website only specifies firearm death. It doesn't actually specify death by 50 caliber bullets, for example. Same thing as emphasized in the 2019 Honolulu Police Department annual report. It cites firearms deaths, but it doesn't cite anything specifics to 50 caliber rounds or capable firearms in general. Moreover, it also causes an enforcement problem. The bill as written also specifies that just mere possession of firearms that can take 50 caliber rounds without, again, specificity, whether it's 50 cal BMG or the other calibers in existence, also does include shotguns. And so it raises a question: what about lawful owners of shotguns and those who already registered firearms and rifles that already had that already have the capacity to fire 50 caliber bullets? Are they supposed to just turn them in? It doesn't specify, the measure in its current form doesn't specify that. And the thing I wanted to close out with is the fact that in order to better serve the public, in order to address violent crime or anything of that matter, what you need is a law enforcement response, a timely one. Anyone can call 911, yes, but in order to respond to a violent situation, we need law enforcement personnel there ready to respond, not someone waiting for someone to show up 5-10 minutes at a time. Also,
Thank
that's
you
why I
very
want
much. I'm sorry, my staff telling me that I accidentally skipped Michael Elliott. I see you there, Mr. Elliott. Go ahead.
Thank you, Chair and honorable senators. My name is Mike Elliott. I'm testifying as a private citizen. The Second Amendment is obviously an individual right, and it precludes the government from taking action with regard to that individual right of firearms ownership. It has been enshrined in the Bill of Rights in 1791 and has been continually reaffirmed in various court actions over the years. Even a case in Georgia in 1837, where the court actually had ruled that the court held the Bill of Rights protects natural rights, which were fully capable of infringement by states and federal government. And the Second Amendment provides the right of the whole people, old, young, men, women, and boys, not militia, to keep and bear arms of every description and not merely such as those used by the militia. The 50 caliber round has been in common use well before the before the Revolutionary War, through the Civil War, and on through generations. There are numerous people that actually, as myself, I do competition shooting with large calibers. And this is a continued infringement. Once you start with one caliber, then you're going to say, well, now this one is the quote bad caliber. And you're going to come after that one and the next one and the next one. I say that you have no right or authority to actually pass this bill or even introduce it, that it is unconstitutional. And if it were to be passed, would be found unconstitutional in a follow-on court challenge.
Okay.
Thank you.
All right. Thank you very much. Justin Lee Solomon, is he here?
Hi, Senator Rhodes. Justin Lee Solomon is not in the Zoom room at this time.
No, okay. He's in opposition. I think that's all the ones we have that signed up. Yes. So there's a huge number of people opposed, roughly 500, 510, something like that, with 3 or 4 in support, and there might be a couple ones with comments. No, it seems to be a pretty polarizing bill. They're almost all opposition. I think that's it. Oh, I guess members' questions. I'm sorry. Members, any questions? Let me see if I have any here. Hang on.
Yes, sorry, Chair.
Senator Favela, go ahead.
Yeah, I mean, reading into the bill, I just wanted to know what would be the first reason, and then what would be the benefits of this regulation on this bill?
Well, I don't know. The reason that I introduced it was that a 50 caliber sniper rifle can kill somebody from a mile and a half away, and I think we need to talk about, you know, on a spectrum of a BB gun on one end and a tactical nuclear weapon on the other. What do we want in private hands? And at what point is it just a military weapon? And at what point is it a legitimate weapon for self-defense and hunting and the things that private individuals do with them? So that's the reason for it. You know, my recommendation there'll be we can talk about the recommendation later, but that's the reason for it.
Okay, I guess, yeah, because, you know, and I know we've all had a lot of emails, and a lot of guys, mostly the most of emails that I got was because of the shotgun. You know, the guys who do skeet shooting, competition shooting,
I'm aware
and
of that.
even bird shooting. They're just really worried about the parameters of it. Okay, thank you for the information.
Thank you, Senator Casio.
So I'm wondering if the language could be amended to address those issues of the shotgun.
Why don't we see? Let's ask questions of anybody. If anybody wants to ask questions of the testifiers who came, let's go ahead and ask them, and then we can go on to decision making. Any questions for the testifiers? Okay. If not, why don't we, Matt, if you don't mind, can you put us into a separate room for the decision making today? Okay, coming back in for decision making on today's agenda. First up today is SB 540. This has to do with making it easier or making it possible for the governor or the mayors in an emergency order to have lesser penalties than a misdemeanor for whatever violations they feel or deem are necessary. So we did post a proposed SD1, which we will use as the basis going forward, but we do have some amendments to that proposed SD1. So instead of combining traffic, actually, I'm sorry, we'll accept many of the recommendations made by the Judiciary, Attorney General, and Honolulu Prosecutor, which we believe are consistent with each other. Instead of combining traffic and emergency period infractions, we'll keep them as separate definitions and make relevant amendments throughout the chapter. We'll allow the officer to ask for the offender's email address when issuing the notice of infraction and allow use of the email to contact the offender. We'll authorize concurrent jurisdiction of the district court for infractions involving minors, which is the way it's done for traffic infractions now. We'll specifically amend certain sections in Chapter 291D, which is the traffic infractions chapter, to clarify the chapter's application to emergency period infractions, including cleaning up the references to the Traffic Violations Bureau and Traffic Division. Also, there'll be some clarifying language in Section 127A 29, which is 127A is the emergency emergency powers chapter. And since this is an important bill, I'm going to ask my staff, is that everything?
There may be other general technical amendments as necessary.
Okay. Technical amendments as well. Okay, questions, comments, concerns? If not, Vice Chair.
Okay, members voting on SB 540, Chair's recommendation is to pass with amendments. Chair Rhodes?
Aye.
Vice Chair goes aye. Senator Ocasio?
Aye.
Senator Gabbard?
Aye.
Senator Kim? Senator Kim?
Couldn't hear you.
Sorry, aye.
Senator Lee?
Aye.
Senator Favela?
Aye.
Chair, your recommendation is adopted.
Thank you, members. Next up is SB 1359. This establishes an offense for placing written material on state or county property without written approval. We got extremely late not late testimony. This is extremely late testimony from the Department of Transportation. So I haven't had a chance to really look at that. So I'm going to defer this until Tuesday, February 16 at 9:15 a.m. in a video conference hearing like this. Okay, that takes us to SB 148. I mean, we'll defer it for decision making. SB for 148, this requires certain landlords, lessors, or plaintiffs in a summary possession action provide proof of payment of taxes due to the state as a condition of the issuance of a writ of possession. Our recommendation here is to go ahead and move it forward with a significant amendment. Will require only that before you can get summary possession, you have to produce a valid GET license, a GET license that's in good standing. It's not foolproof, but at least if the person is just not paying any taxes to anybody, then it's pretty clear at that point that there's an issue. And we'll put a bad date on it, May 6, 2137. Questions or concerns? If not, Vice Chair.
Members voting on SB 148, the chair's recommendation is to pass with amendments. Noting the presence of all members of the committee, is there any opposition? Any reservations?
Reservations.
Reservations for Senator Favela. Chair, all other members vote aye. Recommendation adopted.
Thank you. Next is SB 163. I think it doesn't sound right, but maybe it is. Yeah, okay. This would amend the statutory limitations on the time period in which a survivor of childhood sexual abuse may file a civil suit. It allows for punitive damages, permits the court to order restorative justice measures at its discretion if requested by the victim. And the recommendation here is to accept the AG's amendment, which were technical in nature, and that's it. Questions or concerns? If not, Vice Chair.
Members voting on SB 163, the chair's recommendation is to pass with amendments. Noting the presence of all members, are there any no votes? Any reservations? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 1286. This makes an appropriation to the Office of the Prosecuting Attorney for Hawaii County for the Career Criminal Prosecution Unit. Recommendation is to pass as is. Any questions or concerns? If not, Senator Keokalole.
Members voting on SB 1286, the recommendation is to pass unamended. Noting the presence of all members, are there any noes? Any reservations?
Reservation.
Reservations for Senator Favela. Chair, all other members vote aye. Recommendation adopted.
Thank you. Next is SB 288. This would establish the offense of unauthorized attachment of object to a fence, gate, or wall. I'm going to defer this. No testimony in support. And that brings us to SB 307. This is relating to firearms and includes any firearm or rifle with the capacity to fire ammunition of 50 caliber or higher to the list of prohibited weapons. Recommendation here is significant amendments. We'll take out shotguns, we'll take out muzzle loading firearms, put on a bad date, May 6, 2137, and there'll be technical amendments as well. Then we'll also add in the committee language, we'll note in the committee language that the committee interprets HRS section 134.11 as applying to privately owned weapons as long as they're used in the scope of official duties. So 134.11 is the exemption for basically all the gun laws are exempted if you're in the military or in the police or in part of your work. The wrinkle was if the weapon is privately owned and you use it for work, does that still count? So we're going to put in the committee report that it's our opinion that it does. Questions or concerns? Noting the Senator Gabbard.
Chair, as a strong supporter of the Second Amendment, I'll respectfully be voting no on this measure.
Okay, thank you. Anyone else?
So me, Chair, I'm voting no.
Okay, thank you. Any other questions or concerns? If not, Senator Keokalole.
Members voting on SB 307, the chair's recommendation is to pass this measure with amendments, noting the opposition votes of Senators Gabbard and Favela. Are there any other, and the presence of all members, are there any other members with reservations?
I have
Any other
reservations.
reservations for Senator Ocasio? Any other members with reservations or opposition? Okay, seeing none, all other members vote aye. Chair, recommendation adopted.
Okay, so I think that's it. Did I get all, staff, did I get all the bills?
Yes.
Yeah, okay, then we're done for today. Our next hearing is tomorrow. This is unusual, and we don't usually have hearings on Wednesday, but we have one tomorrow, so I forgot what time it is, 9:15 or 9:30, something like that. All right, thanks very much. See you at the floor.